moment ago, case number 10216 versus Secretary of the Registry Board.
I like it. Campbell.
Good morning, Your Honors. Chief Justice Marshall. May it please the Court, my name is Attorney Brandon Campbell, and I'm here to represent the petitioner appellant in this case. Before we get into the specifics, what I'd like to say is that the principal issues in my brief, and that is whether or not the Board should have been required to present expert testimony in this case, whether the hearing examiner can reject the opinions of two experts without any proper basis, and whether the Board can make a decision as to risk without objective measures. All of these arguments go to reliability of the risk determination. And of course, that affects the level of dissemination that is given to the community. What I want to say here, the whole purpose of this statute is to protect the community. And if we're going to have a process that protects the community, that entails that the community receive the proper level of notice for people in these cases. So I would caution this Court not to automatically view the Board as the one wearing the white hat in this appeal. The arguments made by the Board do a lot to tear away the underlying science from the risk determination process, making the process less reliable. And in cases like that, if the process is less reliable, you will have situations where people, former offenders who present a relatively high risk, will be underclassified, and conversely, offenders who present a relatively low risk will be overclassified and unfairly branded as worse dangers than they really are. But I would submit in both of those situations that the purposes of the legislature and the society's interest in receiving accurate information is undermined. Now, I want to proceed to my first argument in my brief, which is about whether or not the Board should have been required to present expert evidence in this case. And it's basically, there's a two-part analysis to it. One is under this Court's case in Commonwealth versus Bruno, and the other part is a due process analysis. In Commonwealth versus Bruno, which was an SDP case, this Court found that there should be expert evidence in order to temporarily commit somebody. The Court did not go into any in-depth statutory analysis about how this should be done.
At the initial classification stage that he is sexually dangerous, you have expert testimony, don't you usually?
I'm not an expert in SDP proceedings, but it is my understanding at the first stage to temporarily commit somebody in order to go to the next stage where there's a probable cause, that there must be some kind of evidence presented by the Commonwealth.
Because you've got to show the test for sexual dangerousness, which is mental abnormality, or there's another couple of prongs to it that I can't remember right now. And inevitably, the Commonwealth brings in, almost always, an expert. So the question then is, having done that through expert testimony, why do you need an expert when you're just now, thereafter, simply attempting to see what level he ought to be at? Because we already know by expert testimony that he's dangerous.
There is a two-part analysis in classification proceedings, and the other part of that analysis is the risk. The risk, if a person is not at any risk of reoffense, it corresponds that they're not in any danger. Now, with respect to going back to Bruno, this Court said that determinations as to risk are beyond the ordinary ken of the fact finder.
Well, not exactly. I mean, determinations as to risk based on mental abnormality may be beyond ordinary experience, which is what they were talking about. Really?
That is an argument that my brother has made. It is not my reading of Bruno. I read Bruno as saying that there are two distinct distinct prongs, and that one of those is mental abnormality and the other is a determination as to risk. But let me say in this case,
as to risk based on that mental abnormality.
that would be the flip side.
Likelihood of committing another offense based on that abnormality. That's what the SDP is all about.
I would say in this case, because the petitioner has been diagnosed with a mental abnormality, if a mental abnormality is indeed the litmus test, then this petitioner should be entitled to prevail.
No, I'm talking about the SDP proceeding, which is critically and most importantly based on abnormality. I mean, Kansas versus Crane couldn't have been clearer that what we're talking about here is mental abnormality creating likelihood of danger. We're not just talking about your run-of-the-mill recidivist, which, if they don't have an abnormality, they can't be committed under the Sexually Dangerous Person Act. Right? So, I mean, there's a difference there. And what we're doing here is not assessing whether someone has a mental abnormality and, as a result, is likely to be dangerous, but rather what the risk of reoffense is for this person, whether or not they have a mental abnormality.
Well, I would respectfully disagree. We have a hearing examiner who used a mental abnormality in part as a basis for finding an increased risk.
But it's one factor. It's one of 24 or 38 factors, depending on how you count them.
It's one of the factors, but if indeed it brings it into the realm of expert testimony, then they should have had it in this case. But more importantly, I don't think that reflects the reality of risk assessment. If you look at all of the factors, 803, CMR 1.40, there are many, many factors that are not related to a mental abnormality.
Precisely.
So it's not...
Exactly. That's my point. My point is that most of the factors have nothing to do with mental abnormality. That's just one factor that could be considered amongst all these others in the classification process.
Then I guess I'm agreeing with you in that instance, but I still make the argument that even though that there are factors that are not mental abnormality, that doesn't mean you don't have to have expert testimony.
So we need a risk expert.
You need a risk expert.
Do we need one at a bail hearing?
You do not need one at a bail hearing. You do not need one at a parole hearing.
Or a bail revocation hearing where, based on risk of danger, you can...
Well, I would take parole hearing out of there because there's no liberty interest in that case. But these types of proceedings are fundamentally different from those. Number one, I would say the whole purpose of the statute is supposed to be remedial. We should not be treating these people as criminals. And anything that you do to treat them that way brings the statute more towards a punitive effect. But more importantly, I lost my train of thought. Sorry, what was your questions?
Well, while you're thinking about the train, as you know, two psychologists, two experts, found that he was a pedophile under recognized standards in the DSM-IV, but found he wasn't sexually dangerous, which...
Correct.
And then I got a footnote I see in the judge's opinion that their reports aren't in the record, except for one of them, the record in front of her, which would be the same as the record up here, except for the last page of Dr. Joss's report. So that kind of hurts you, doesn't it?
The entire report of one of the experts, qualified examiners, Dr. Silverman, was admitted. The final page of a report by Dr. Joss was admitted, not the entire thing, but the final page, which I submit as the most important page, which has all of the conclusions and as to why.
Right.
Based on
the final page, I'm sorry, just Sal, go ahead.
I just want to know where the rest of the report is.
I was not the attorney down below, but
so we're missing
it was admitted by the board without any objection.
So we're missing a lot of stuff in those reports, two reports, which could maybe sway us a little bit to your position. But there's nothing we can do about that because they weren't introduced in the Superior Court.
Well, I think there's quite a bit in that one page if you look at it.
His conclusions are in the page, and I've read the other report. It looks like it's in there in its entirety. But Dr. Joss's conclusions, I think, are very important. It's the opinion of the undersigned that Mr. Blix does not constitute a sexually dangerous person as defined in 123A, Section 1, which is someone suffering from a mental abnormality who's likely, therefore, to commit another crime unless he is confined in a secure facility. That's sort of the standard Dr. Joss says he doesn't meet that standard. But what does that say about someone being classified under the Sex Offender Registry Board?
Keep reading, though. He also says that he is at a quote-unquote low risk of reoffending. He did not have to say that in order to nix an SDP determination. And that brings me to what the...
Well, I don't see that precisely. It just says that he's not a sexually dangerous person as defined.
I can tell you it's at exhibit page 183.
183, that's not his report. This is survivors of sex addicts and sex addicts and their families. In any event, we can look
In
at
any
the
event,
record.
yeah.
And we'll look at it.
I'm sure that you'll find if you read it, take time to read it slowly, you'll see
the
it.
other report says that, he's at a low risk as long as he keeps to this program because he's got a whole bunch of things he needs to work on. But we have a sense that he doesn't need to be securely confined as long as he's under this strict program of supervision, which is all well and good for the SDP point of view, but for a risk classification for the classification system, how does that help us? What if he decides not to do what the probation department? I mean, the implication here is if he doesn't do what the probation department requires with respect to all of these aspects of sex offender treatment, he's not such a low risk. So in assessing whether he needs to be confined to keep him from reoffending, that's one set of issues. To assess whether or not he should be classified for purposes of the Sex Offender Registry Board, isn't it quite a different set of criteria and circumstance?
I'll concede it's different, but if you look at the findings, I mean, you've got one saying that he's at a low risk of reoffending.
Yeah, so long as he continues to do all these things.
I don't read it that way. I would disagree with that. And the other one says that he's not likely to reoffend. These qualified examiners knew that by not making an SDB determination, that this person was going to be out in the public. And that's the problem I have with the hearing examiner's findings. The hearing examiner, what he really did is he substituted his own judgment and said, well, I recognize that these two QEs said that he's at a low risk. But in my judgment, these people who commit these types of crime are only at a low risk when they have undergone a long battery of sex offender therapy. And that's not what these conclusions are about. These qualified examiners knew that this guy was going to walk out the door if he wasn't SDP.
But trust me on this. Look what the doctor says here. 5 years of probation with outpatient sex offender treatment should be sufficient to allow Mr. Blix to safely live in the community. Well, what does that do for the community during the 5 years where he's sort of on probation? Maybe he's going to do all the things the doctor says he needs to do, or maybe he's not. The
real import of that is that he is being watched and that he is being treated.
And therefore
that is exactly what he was doing in this case.
Doesn't need to be confined in a secure facility, which,
Correct.
Of course, is the ultimate conclusion here.
Correct.
But it says nothing about whether he might be at risk while he's in the community under this probation, which he may or may not comply with.
Well,
it says that he is the implication is that, of course, he is a risk until he does all of these things and proves himself over this 5-year period of probation.
I think if you turn that around, you'd have to conclude that these qualified examiners really thought that there was a big chance that if he was released that he could reoffend, and I don't think that that's what they thought at all.
Mr. Campbell.
That's true with everybody who's on the Sex Offender Registry Board. They're all out there in public. If what you say is true, it seems to me the logical extension of that is if they're not sexually dangerous, there should be no sexual offender requirement.
That's not what I'm saying at all. I'm just saying in this particular case, given the findings by these two psychologists who are saying that this guy is at a low risk, when he is released, he is on probation and he is attending sex offender therapy, which he complied with his probation, he went to his therapy, he was in full compliance according to his therapist. All of this is in the record that he would not be at a
But at the time of this hearing, he hadn't. I mean, the probation, it was a couple of years into the probation, right?
No, he was still being held, I believe, at the treatment center.
So he hadn't even started his probation.
Correct.
Mr. Campbell, may I ask you some questions?
Yes, ma'am.
Is it your position that because this is a level 3 classification, that expert testimony is required, or because of the opinions expressed in the earlier SDP proceeding?
It is my position. CPCS has taken the position in their amicus brief that because that this is a level 3 case and level 3.
I know what they've taken. I'm just asking you what your position is.
My position is that in any one of the classifications, there needs to be expert testimony.
Now, as I would, and are you saying expert testimony on behalf of the board? The board should call its expert?
I misspoke. Let me say expert evidence, and let me say, to answer your question, yes, by the board. What we're talking about here is the quantum of the evidence presented. That's what really this appeal is about.
As I read CPCS's brief in this case, there's also a claim that when petitioners, offenders, seek to have funds made available to them because they want to present expert testimony, is there anything in this record that says your client sought to have his own expert and was denied funds?
Yes, he filed a motion prior to the hearing requesting funds for an expert, and that was denied by the hearing examiner in the hearing examiner's decision.
Is that here on appeal?
Yes.
Okay.
In your brief?
Yes.
So there are two different questions here, and that's why, frankly, that had not emerged when I first looked at it. There are two different questions here. One, what is the right of a petitioner, offender, somebody who challenges the classification? Because we're at the stage where he's been classified and he's challenged, correct?
Yes.
Right. So he's now before a new hearing officer, am I correct? And he says, I want to introduce expert testimony, and he was denied that right?
He was denied funds for an expert. Let me be clear, because I may not have answered your question correctly.
I don't see that it's in this brief.
It is. We are not raising the issue of the denial of the funds for experts. What I meant to say is, of course, we're arguing that the board, as a matter of the quantum of evidence, should have been required in this particular case to do that.
Now I am truly confused.
Okay, I apologize.
No, it's okay. Well, unfortunately, I did not bring to the bench for some reason today your brief, so I don't know what relief you are what relief you are asking for.
We are asking that Mr. Doe be classified as a level 1, which is what the expert testimony supported, the uncontradicted expert testimony submitted by the board, or in the alternative for a remand.
For a new hearing.
For a new hearing.
With expert testimony, presumably.
With expert testimony.
By the board?
Well, by whoever.
Before the board.
Before the board.
And it's your position that the expert testimony is required in every case, regardless of whether one of the elements is a mental defect or a mental illness? As you know, this is a two-part process. There is an initial classification and there is a final classification. I'm not arguing that there needs to be expert testimony at the initial classification. If a petitioner doesn't like that, they have the right under the regulations to get a full hearing on it. At that point, there should be expert testimony if there is, in cases where there is a real dispute as to the positive factors and the aggravating factors and the mitigating factors. There could be cases where it's lopsided all one way or the other. I'm not saying that expert testimony would be needed in those cases, but here, definitely in this case where there's major differences in the positive and negative factors, there should have been expert testimony.
May
Okay,
I ask you this?
can I just ask one just quick follow-up on that? So you are saying there was not substantial evidence to support the board's conclusion?
Correct.
You are not asking for a broad brush rule that says there must be expert testimony in every case?
He is. You are, aren't you?
I am. Let me put it this way.
You're protecting your client.
For the initial classification, because the petitioners currently have the right to what amounts to a brand new determination.
No, I understand that.
In those cases, those people that don't challenge that, if there's no expert testimony, I say fine. If people challenge it, former offenders challenge it, and it comes down that there is a serious,
And what?
Now, what I anticipate is that in many cases there will be a serious dispute about the aggravating and mitigating factors, and that there will be expert testimony. But I'm open to the possibility in another case where the board may not need expert testimony to prove its case.
I'm okay. You've answered my question.
Thank you.
Thank you, Mr. Campbell.
Oh, he's got to argue.
Oh, sorry.
Morning.
Mr. Les, I'm sorry.
It is the board's position in this case that the Superior Court properly concluded that expert evidence is not required as part of the board's case in proving risk and dangerousness at a 178L hearing in these matters. There's two ways of looking at this issue. I think the first issue is looking at it from a statutory requirement. What does the statute require? And the statute here is unlike the SDP statute, which plaintiff relies upon as his linchpin for saying that expert evidence is required, where that statute does require expert evidence. The SORB statute is silent on that, and the two statutes were enacted together simultaneously as a single omnibus act. The fact that that was omitted, was included in one section, the legislature was certainly aware of it, and didn't require it in the SORB cases. What the legislature said is, if you are going to use, if the board can certainly use expert evidence if it chooses, or use an expert. If you are, and you're facing an indigent offender, you're going to have to provide funds for that offender.
Can I ask you this, though? I understand the statutory argument, and I think you're correct on that. But I'm really looking at sort of the Bruno argument outside of the SDP context. Don't we have a similar situation here? I mean, the assessment of whether someone will commit a sexual offense seems to me to be a little bit beyond the common experience that someone would bring to this, isn't it?
I think certainly in the SDP context it is. And
I understand that.
The Supreme Court certainly recognized that in the two Kansas cases, and this court has enumerated that in Bruno and Dutiel. But when you get out of that context, and where the linchpin and the critical constitutional issue, not only constitutional but fact-based issue, is the existence of a personality disorder or mental abnormality, something that the Supreme Court has called a volitional impairment. When you get out of that context, you're going into a totally different context. You're going into a totally different risk assessment context.
A different one, but equally as complex?
It is in some ways, but it is a risk assessment that is akin to the type of risk assessments that go on in any number of circumstances in the courts, in any number of other agencies, in any number of other places throughout the world that don't rely on expert evidence, because what the board did here, as it was required to do by the statute, was bringing in its expertise to bear, looking at the factors that the legislature said, these are the things that we are concerned about, looked at that, sat down, and parsed that all out in a detailed scheme of 24 factors, including, if you include sub-factors, up to 38 factors here, and parse those out in a way that a non-expert can look at those factors and balance them out and see them. Adding expert. Oh, I'm sorry.
No, it's okay. So the necessary expert information is embodied in the regulations.
Correct.
The factors.
Correct.
I noticed that argument in your brief. But so how do they get attacked? I mean, let's just. Oh, that's very interesting. But the science is so far beyond factor number 22. How does that get challenged?
I mean, certainly offenders are certainly free to challenge the regulatory factors. Can be challenged. Can
they be challenged by expert testimony?
It could.
If the petitioner is indigent, is the Commonwealth required to provide funds for that person?
Under the statute, only if the board used an expert.
Oh, I understand that, but you've just, I understand what the statute says, but I'm now asking you whether, if the board uses an expert, that's not an issue. If the board says, well, actually, my expert conclusion is embedded in, what has happened hitherto, why should the petitioner not be given an opportunity to challenge that?
Well, because there is certainly the regulatory factors. There was an opportunity when the regulatory factors are promulgated. It goes through the regulatory promulgation process, an open hearing, and people can certainly come and comment on those, and that was done, and no one has ever challenged, and not certainly in this case.
That's not an issue in this case. I don't see why we should bother with it. He asked for funds for an expert. He didn't get it. He hasn't appealed that. You didn't use an expert,
right.
So it's not an issue in this case.
I would agree with that, and it's amicus raises
so the
issue.
abstract question about, well, should they have experts, should they not have experts? If the Commonwealth gets it, they get one, but that's another day.
I would agree. I would agree with that.
Let me ask you the question about the expert, about the decision of the board to call an expert. Isn't the rule on expert testimony that if the subject matter of particular testimony is beyond the ken of the average person, then expert testimony is required? But if the subject matter is within the ken of the ordinary person, expert testimony is not even permitted.
That's correct.
So how can the board decide that it wants to use expert testimony in a case where it has the option? There's something contradictory about it.
There might be situations where it hasn't happened to my knowledge yet, but that there might be situations, particularly with a factor like the mental abnormality factor. If there was going to, that is a factor, is whether the person is presently suffering from a mental abnormality.
That's been determined.
Correct.
It's already been determined.
And there they usually have an expert.
Right. But if there was a case where that was something that concerned the board in proving its case, they would have to if they wanted to invoke factor one, they would have to probably use some form of expert evidence to do that, as was certainly the case here.
So if a mental abnormality is going to play into the mix of predictive behavior, then the board would have to use an expert.
It's a better chance that the board is probably going to have to do that, because it's going to be very difficult for the weight of cases suggest that if you're going to suggest that whether somebody is suffering from a psychological or volitional impairment, that there would have to be some sort of expert.
Well, could a respondent hire an expert without asking for money?
Sure, and they do, and they do.
And they often do. I asked the question rather thoughtfully, which follows up to Justice Spina's. First, I find it a little troubling that the board will permit expert testimony if somebody can afford their own expert, but not permit it if somebody can't. That's one problem. But here, looking at the judge's decision, the Superior Court judge's decision, describing the background before she gets into the discussion, she says, the hearing examiner gave credence to the reports of expert witnesses. So even within the statute, it's not that the board may have called another expert. The board is giving credence to the reports of expert witnesses. Why, in this case, on what conceivable grounds can the board then say, but you're not entitled to expert testimony?
What the board was relying on was the historical diagnosis that there was pedophilia, which was not a disputed issue in this case. He did not dispute the fact that he had pedophilia. In fact, part of his theory of the case here was, I am a pedophile. He says in his closing counsel says in her closing argument, he realizes that there's no cure, but despite that, he represents a low risk because of all of these ameliorating factors. So that certainly in this case, there was nothing to dispute. There was nothing to do. And the board was not necessarily relying on those reports for their ultimate conclusions, because under the regulatory factors, under the board's regulations, expert evidence only comes in if on the ultimate issue of risk and dangerousness, if the expert actually comes in and testifies, which didn't come in. So in fact, the hearing examiner gave these reports more weight than they were probably entitled to. The report can come in for all the other reasons that it can come in and can be considered, but not the ultimate issue. And for good reason in this case, because these reports were done in the context of an SDP evaluation, which is a very different risk assessment in terms of determining whether that person represents that high level of risk because of a presence of a personality disorder or mental abnormality, that they need to be confined at the treatment center.
I don't disagree with your representation. That's for whatever purpose the hearing officer was using that report. But at least as I read the statute, it says in any case in the classification, please intend to rely on the report of an expert witness. I see prepared specifically for the purpose. Okay, forget it.
Yeah, well, that's the point is that if the board retains the funds for
I understand.
actually for the purposes of this case, then we'll do it. And that wasn't what these were reports that were prepared.
Mr. Less, to your knowledge, has the board ever allowed an indigent respondent on a motion for cause shown the request for money to pay for an expert where the board was not going to rely on an expert?
No, it has not.
So
that's a policy of the board in essence.
It's a
right. Well, we follow what the statute says. The statute says that an indigent offender may receive funds if the board uses an expert that was that prepared a report for the purposes of this hearing. So the board has never done that. The board has never authorized funds or has denied the motions for funds in all the other cases. And in this case, the issue about the lack of expert evidence here doesn't rise to a procedural due process violation either, as plaintiff alleges in this case. There's been no showing that the introduction of expert reports would provide a more accurate determination, because what you're essentially having here is because the bulk of the risk factors here involve traditional criminal history type factors. The expert is only making a I think an assessment on the actual risk itself, which is what the hearing examiner ultimately has to do. So they're looking at the same factors that the hearing examiner is going to look at and give their opinion. And the hearing examiner can, and if there's opinion testimony, can believe all, some, or none of the evidence. It's not, they don't have to rely on the final conclusion of any expert that's put into evidence. So it doesn't add any additional benefit or any additional accuracy to the ultimate decision.
Are you able to tell us, I know this isn't in the record, but are you able to tell us an approximate percentage of cases in which the board calls experts?
We've never called an expert.
And do you know how many cases in which, where you don't have an indigent, the respondent petitioner has called expert testimony?
I don't
mean percentage, frequently, infrequently?
I can tell you, anecdotally, I would say it's about anywhere from 5 to 10% of the cases. And I can also tell you anecdotally, it doesn't necessarily change the outcome of the case. In fact, a lot of times expert evidence can hurt an offender's case because the expert will come in and say, well, he's a pedophile, or he suffers from post-traumatic stress disorder, or has an antisocial personality disorder, and then gives the offender factor one, the mental abnormality factor.
That's not a basis for our concluding that the person is or isn't entitled to have expert opinion, correct?
I'm sorry?
That's not a basis for our determining.
Oh, no. I'm just saying anecdotally how it works. I mean, and the opinions, some of the opinions are, it's very case specific, and really the stronger the case, the stronger the facts of the case are, the stronger the opinion testimony is, which again goes to the lack of accuracy. It really gets down to not so much whether you have an expert in the case, but what are the facts of the case and how those facts interplay with the regulatory factors. And if the facts of your case show that the low risk factors or the risk ameliorating factors are weightier and affect your case greater, then that's going to ultimately reduce your risk. But if they, as in this case, tend to show that that high risk factors are in play and the risk ameliorating factors are of a lesser degree, you're going to get you're going to get a higher result. And that interplay with whether or not you have experts for the board or for the offender aren't really going to be the gravamen, linchpin important thing that's going to win the day. It's ultimately going to be the interplay of all of the factors together. Unless there are any other questions, the board will rely on its brief.
Thank you, Mr. Lewis.
Thank you.
All rise. Hear ye, hear ye.